Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. I previously did a video about Naomi Arbabi, a lawyer who sued her neighbor, which would be completely unremarkable, except she went full-on sovereign citizen style crazy in it. So I covered that in a previous video, you can check that out. But if you need a little recap, essentially what happened is that the neighbor had a privacy divider built on her property, and this was built by the Strata Council because of reasons that we don't need to get into. But Naomi Arbabi was upset by this because the privacy barrier was blocking her view, and she said this view was the crown jewel of her property, and so she wanted inordinate amounts of money. She wanted $1,000 a day for every day that this was up. This is, of course, ridiculous, and she filed the most crazy documents. So, at the time, I said, this is not going to go well for Ms. Arbabi, and sure enough, I was not wrong. Let's follow up with the conclusion of this, and this is the decision. Naomi Arbabi and Colleen McClelland in Vancouver, British Columbia. So, introduction. The defendant applies for an order striking the plaintiff's notice of civil claim pursuant to Rule 9.5 of the Supreme Court Civil Rules. Essentially, the defendant wants the lawsuit thrown out. The defendant, of course, is the neighbor. Naomi Arbabi is the plaintiff. They then say, although both the plaintiff and defendant are self-represented in this action, it is important to note that the plaintiff is a practicing member of the Law Society of British Columbia. This is a statement that aged, I was going to say like milk, except milk sometimes turns into cheese. This aged more like a garbage can full of used diapers in the hot summer sun. So let's keep going. Background. The background facts are not clearly set out in the pleadings or application materials. Now, this is pretty common when you've got self-represented individuals, but really should not be the case when one of those is a lawyer. So, what follows are the facts that I've pieced together from those documents and from the parties' oral submissions. The facts do not appear to be particularly controversial. So the plaintiff and defendant are owners of non-adjacent units in a condominium building located on West 8th Avenue in Vancouver, BC. Each of the strata lots in question have access to a rooftop deck, which means these have got to be quite nice apartments. So it is undisputed that the rooftop decks are limited common property as defined in the Strata Property Act. When the plaintiff viewed Unit 304 prior to purchasing it, there was a clear glass divider between the rooftop decks of Unit 302 and 303. The plaintiff claims that the clear glass divider afforded her views of the ocean, mountains, bridges, and Stanley Park, and that those views influenced her decision to purchase Unit 304. Now, this is important. You don't actually have a right to a view in this particular area. There's some places where you do, but the problem with a right to a view is that it's essentially a right to control what other people do with their property. And so typically if your view goes across somebody else's property, they might be able to build something that blocks it, and there's very little you can do about that unless you somehow get some sort of, easement or other right over their property, and you'd probably have to pay them for it. So the defendant's evidence is that years ago, so the neighbor, the original rooftop privacy divider between units 302 and 303 was removed and disposed of by the owner of unit 303 without any authorization from the building strata council, i.e. some previous person did some damage, but it gets worse because the strata council had some thoughts about that disposal. So, minutes from December 19th, 2019 indicate the following under the heading Deck Dividers. Strokes Renovation will be providing pricing on deck dividers. Once the plans have been finalized, a meeting will be set up with the third floor owners and the plans will be implemented. So this is before the lawsuit was filed, before any of this was going on. The Strata Council was already planning to replace some of the deck dividers. It is clear from the minutes that replacement of the deck dividers was on the Strata Council's agenda long before the plaintiff purchased her unit. Now, when you're looking at buying a place that has a strata council, one of the things you would do is look at the minutes. This would be a very basic stuff. I don't practice in this area. This is not my area of law. And yet I know this because this is like elementary stuff. You look at the minutes for the Strata Council to see if there's something that affects you there. You know, are they going to be spending $10,000 on, I don't know, exterminators for a rat problem? Well, that's the kind of thing you might want to know, and you'd find that out in the minutes. Are the roofs failing? Is the pool about to be super expensive? Is the view that is cherished to you about to get changed? This is basic due diligence, and it's a bad look if a lawyer is missing that. If I was buying into a Strata Council property, I would certainly be reading the minutes myself. I would also be wanting my lawyer to read over the minutes to make sure there's nothing of concern. So, on or about September 5th, 2023, a contractor hired by the Strata Council reinstalled a privacy divider on the limited common property adjoining the defendant's strata unit, which has partially obstructed the view previously enjoyed by the plaintiff. It doesn't like completely block it either. It's just a small thing in the way. The plaintiff claims that the defendant somehow influenced or caused the Strata Council to install an opaque divider to replace the transparent divider. Now, I don't know if you've ever lived in a strata location, but I can tell you the Strata Council doesn't really care what you have to say. They tend to be they're sort of the equivalent of an HOA. They're going to be busybodies. They're going to tell you what you can and can't do, like what color you can paint your wall, what color curtains you can have, all of these kinds of things. So neither of the parties to this action is a member of the Strata Council. Okay, so far we've just laid out the basis of the dispute, but now here's where things are going to start getting weird. Because I already mentioned that they were going to get weird. Told you that this was sort of sovereign citizen stuff. Here we go. So notice of civil claim. Inner notice of civil claim filed October 5th, 2023. The plaintiff claims that the defendant caused to be installed a 66.5-inch tall privacy wall at the border of her part of the rooftop deck, thereby blocking the view of the oceans, mountains, Stanley Park bridges, and more. She seeks compensation from the defendant for trespass, which she quantifies at $1,000 per day for each day until the alleged trespass is remedied. And if you're wondering how did she get to $1,000, she basically said, well, that's how much I feel I should have, so that's how much it should be. And that's not how you do damages in civil law. If you want to show that something is worth $1,000 a day, you have to do some documentation of that. You can't just go with, well, that's how much my feelings are hurt. Unless you can show like some sort of actual injuries. So the trespass alleged is the blocking of the plaintiff's views. The plaintiff's notice of civil claim sets out the following under Part 3 legal basis. Now I'm just going to note, let's assume that she spent, I don't know, $500,000 on this property. Is she saying that she should get, that her property should have been free after like a year and a half because it didn't have the view? That, like, this makes no sense as a valuation, right? The plaintiff's notice of civil claim sets out the following under Part 3 legal basis. So 1, this is a claim of trespass by way of loss as pressed by a woman, Naomi Arbabi, against a woman, Colleen McClelland. Now you're already probably noticing that the language here is weird. And this is a real hallmark of the organized pseudo-legal commercial arguments or sovereign citizen, freeman on the land, Moorish law, this kind of variety of not law, but crazy pretending to be law. And so once the court sees this, they're like, oh, this again. Like the lowercase versus uppercase, the a woman versus person, like all of these things have no value. They have no merit, but people love to try. And this one shows you just how well that goes, because this is going to be one of the biggest legal losses you can imagine over a privacy divider. So this is a claim based on law of the land and not a complaint based on legal codes, acts, or statutes. A claim of trespass by way of loss did arise when, after many attempts to keep this matter private and resolve the dispute peacefully, in a manner that preserves the rights of both sides to the use and enjoyment and administration of their own property, the woman, Colleen McClelland, did not provide a remedy or a lawful excuse. What this tells you is that Naomi Arbabi has got to have gone over to Colleen McClelland's house and made various demands like, hey, tear down this wall. You know, it's Mr. Gorbachev, tear down this wall. And was told, what's wrong with you? Yeah. I state I, all lowercase, of course, did acquire my property at a time when a much lower clear glass divider that was installed previous to this 66.5-inch wall allowed the addition of the aesthetic appeals of the said view to the property of I, and I did rely on views in making the decision to purchase the property of I, and in negotiating a purchase price for the property of I. That, again, that weird language is, yeah. Also, if you made your negotiations for the purchase price and you didn't read the minutes and figure out what the heck was going on, that's a problem for I, a woman, Naomi Arbabi. That's a you problem, not a Colleen McClelland problem. So it's not the defendant's problem here. I state I did conduct due diligence searches to inquire about the conditions of the property. Did you, though? Because it was in the minutes. About the conditions of the property of I and the neighboring properties, and did not find any evidence the woman, Colleen McClelland, having the right to block the view of other properties behind her property. This would have been just basic law school, like Property 101, first year property law. Maybe you should have gone to that for part of your due diligence. I assume you went to it, but learned from it. Therefore, the woman, Colleen McClelland, is stopped from asserting a right to install such a wall on her property that will block the view from the property of I. Estoppel is complicated, so here it's going to suffice to say that alleging estoppel applies to this is just crazy town. It doesn't work. I say herein and verify in open court all to be true. Okay, it gets weirder than that, but we covered that in a previous video. She actually makes this application, and she doesn't just say, I want this heard in court. She says she wants the court to provide her with the building and a judge and all of these resources so that she can turn it into not regular court, but Naomi Arbabi court, which is a thing no one knows what it is. You don't get your own magical court where you get to set the rules, because that would be bizarre. We have courts so that we can resolve disagreements, and everyone needs to have sort of notice of how the courts work, which doesn't happen if you can just make up a new court. That's not... This just makes no sense. So what happens? Well, the defendant makes an application to strike the notice of civil claim pursuant to Rule 951, which reads as follows. So this is a rule that lets you throw out lawsuits if they are awful. And this one is, as mentioned, a giant pile of stink. So, scandalous, frivolous, or vexatious matters. At any stage of a proceeding, the court may order to be struck out or amended the whole or any part of a pleading, petition, or other document on the grounds that 1. It discloses no reasonable claim or defense, as the case may be. So you're suing for something that you can't possibly win at, or your defense can't possibly prevail. B. It is unnecessary, scandalous, frivolous, or vexatious. This one is going to be this one's going to be the magic here. C, it may prejudice, embarrass, or delay the fair trial or hearing of the proceeding. Or D, it is otherwise an abuse of the process of the court. So D is basically any other abuse of process. And the court may pronounce judgment or order the proceedings to be stayed or dismissed, and may order the costs of the application to be paid as special costs. Special costs used to be what was called solicitor and own client costs. Normally in Canada, when you win a lawsuit, you get costs, which is some portion of your legal fees. Now, it's usually not anywhere near the full value of your legal fees. It's just some amount that is much less than what you almost certainly spent, but it provides some remedy to the fact that you had to fight the case. Special costs, on the other hand, is you get dollar for dollar what you had to pay your lawyer, which isn't going to be all that helpful to Ms. McClellan because she defended this on her own. But special costs normally is a very bad thing to have awarded against you. Now, after Ms. McClellan filed this application to strike, the court heard it, and the court reserved its decision and basically took a while to write this up. And that's when I did my first video, and I noted, I think the court is obviously going to have to throw this claim out. They're just going to write a written decision about why and just how bad the claim is. So that prediction is going to be true, by the by. But in the meantime, the Law Society of British Columbia suspended Ms. Arbabi on sort of using powers that are sort of emergency powers to suspend a lawyer. And that's because normally if there's a complaint against a lawyer, they'd just sort of pursue the complaint process. It would take a while. They hear evidence. They do all those fun things, right? But sometimes the allegations against a lawyer can be so serious that you have to step in right now in order to prevent damage or harm to the public. So this sometimes happens when a lawyer is accused of something criminal, or in this case, when the lawyer is accused of not law. Like, this is kind of the opposite of law. This is the arguments you make when you want to not only lose, but be punished for losing. So, yeah, the Law Society said, you can't practice law if you're going to be doing this crazy stuff, because this is considered unethical. It's not just improper. In fact, as a lawyer, if somebody comes to me and they want me to just notarize one of these documents, and then so they're going to file it on their own, but they want my notary stamp on it, it would be considered unethical for me to notarize that document. And I've had to turn people away on that basis. So let's continue. But at this point, she gets suspended while this decision is pending. So the defendant submits that the claim should be struck for the following reasons, and they give 3 reasons, and we're going to look at one of them because one of them is the most interesting. The claim is in the nature of an organized pseudo-legal commercial argument, OPCA, which claims have been found to be frivolous and vexatious by a number of courts. Now, I sort of call this sovereign citizen stuff, although there's actually a whole bunch of varieties and flavors and types of these. There's sovereign citizens, freemen on the land, Moors, various groups, each of which have these theories of how they think the law works that are just wrong and make no actual sense. So we'll scroll to the court dealing with that. The courts collectively call these just OPCA decisions after how they were described in the case of Meads. So the plaintiff began her oral submissions with the following statement. So she's telling the court this to begin. First, I must address that I make reference to I as lowercase I because I am here present in the highest and most humble form. I'm not a freeman on the land, not hung up on a juxtaposition as a sovereign citizen. I don't follow a guru or a teacher. I'm not a member of a church, never heard of the Moorish law. I am not a freedom fighter. And I'm not part of any group or movement, commercial or otherwise. I am not so naive to think that we do not need a legal system, but I do think that our legal system has a lot of flaws. But who doesn't? I'm not here to discuss those flaws. And so she says, I'm not a freeman on the land, I'm not a sovereign citizen, and the court's going to go, bullshit. So, despite this disclaimer, the plaintiff's actions bear many of the hallmarks of claims made by OPCA litigants. Such litigants employ a collection of techniques and arguments to disrupt court operations and to attempt to frustrate the legal rights of governments, corporations, and individuals, citing to Meads and Meads. Meads and Meads is a hugely long case, but it is also a case that has been tremendously influential. Prior to Meads and Meads, these OPCA litigants were really starting to clog up the courts because the courts didn't really know what to do with these people. They'd come in and they'd shout gibberish, and the court would be going, what is this? What is going on here? How do we deal with this? And Meads basically sat down, cataloged out all of the gibberish and explained to other judges what it was, and then also set the roadmap for dealing with it, which is basically, this stuff is an abusive process. Don't give it any time. Just hammer them with sanctions and move on. So, the indicia of such actions were canvassed extensively by Rook in Meads. Some of those indicia displayed in the plaintiff's notice of civil claim are as follows. Here's the things that tell us that this is crazy town. So A, the plaintiff has adopted a double split person strategy wherein she identifies the parties as the woman, Naomi Arbabi, and the woman, Colleen McClelland. She's used these terms in the style of cause and throughout the notice of civil claim. The plaintiff's correspondence with a process server hired by the defendant explains her rationale for this split persona as follows. So, this should be good. I, a woman, Naomi Arbabi, am a living, breathing woman and not a name. When you ask if I am Naomi Arbabi in capital letters, she can use capital letters. Great. The shift key on her keyboard's not broken. The answer is always no, as Naomi Arbabi is an incorporated name and does not refer to a living, breathing woman. Okay, like this is classic OPCA behavior. In a follow-up email, the plaintiff goes on to say, Naomi Arbabi, capital letters, is an incorporated name that refers to a dead entity. The same is true for all names, including yours. Therefore, when you ask someone to identify as a name, they identify as the dead entity corporation, which was created by their birth certificate. I, a woman, am not Naomi Arbabi, but Naomi Arbabi is the name I am called. There's a subtle but crucial difference between the two. Unfortunately, this is not common knowledge yet. It's not common knowledge in the same way that, like, birds are a variety of truck is not common knowledge, because it's just not true and bizarre. So, of course it's not common knowledge because it's just weird. So, B, the plaintiff addresses court officials in an atypical manner. The notice of requirement of court attached to the notice of civil claim is addressed, greetings to the man or the woman who at times acts as the clerk of the court. Her rules of court refer to the man who at times acts as judge or magistrate. So, you just call that person the judge, right? Or the clerk. You don't say greetings to the man or woman who at times acts as the clerk of the court. That's not a thing. The plaintiff purports to demand a court process. I mean, you understand that the court clerk is a human being and, like, isn't working 24/7, but you just address it to the clerk of the court, right? Yeah. The plaintiff purports to demand a court process with her own rules, whereby she can move this claim through the Naomi Arbabi court. The Naomi Arbabi court will not accept any legal arguments, codes, acts, and or statutes, as this is a court in law based on the law of the land, and therefore a presumption of contract does not apply to I, lowercase I. Yeah, that's, again, not something you have a right to do. If you want to have something heard by, the law of the land, go tell it to a bear. There is no law of the land. The rules of the Naomi Arbabi court appended to the notice of civil claim include a requirement that the judge give a specific oath prepared by the plaintiff. If you have instructions for how to deal with court and they involve trying to get the judge to swear an oath or to tell you their oath, throw those instructions in the trash because they are terrible. Although she has commenced a claim in this court, the plaintiff also seems to deny that this court has jurisdiction over her, as the claim says that her mandated use of court forms should not be construed by any man or woman as the submission of I to any legal titles, legal codes, acts, or statutes. Now, the thing about the law is that it applies whether or not you agree with it. That's kind of the point. I mean, that can be good at times. I if somebody wants to murder me, I'm really glad that they don't have to agree that the law says that they can't murder me, or agree with the law that says I can defend myself. Like, oh, whoa, whoa, I'm here to murder you because I don't consent to the laws about murder, but I also don't consent to those laws allowing you to defend yourself. So, and then we get into a big fight over who can not consent to the law harder than the other. Yeah, not how the law works. Result. I am satisfied that the plaintiff's claim falls within several of the grounds set out in the rules we mentioned. In particular, 1, or A, the plaintiff's claim does not set out a reasonable legal basis for the claim brought in this court. You don't actually have a right to the view, and it's not a trespass if somebody builds something on their property. B, it is frivolous and vexatious insofar as it denies the authority of the court. Such a denial is intrinsically frivolous and vexatious, citing to Meads. And C, it is an abusive process insofar as the plaintiff has filed her initiating document as an attempt not to litigate legitimately in this court, but instead to utilize this court's infrastructure for the purpose of her fictional court. And they cite to a case Parhar, which I haven't read, but maybe I should. It sounds like it might be a fun case. Accordingly, the application to strike the notice of civil claim as an abusive process is granted, and the action is dismissed. So, a woman, Naomi Arbabi, her case has been thrown out. And as a result of that, like, Colleen McClelland is in the clear. She's won. Now I'm just going to note here, she did good work. I actually saw her filings, and if I had to guess which one of the filings in this document was prepared, or in this case, was prepared by a lawyer, and which one was prepared by a non-lawyer, I would have gotten it wrong. Like, I would have gotten that one backwards if I had to guess. But the person who ultimately defeats Naomi Arbabi is Naomi Arbabi. So, costs. Given that the plaintiff is a member of the Law Society of British Columbia, again, aged like diapers, she has an enhanced obligation to uphold the rule of law. The introduction to the Law Society's Code of Professional Conduct for British Columbia provides that a special ethical responsibility comes with membership in the legal profession. Indeed, the oath taken by all lawyers called to the bar in British Columbia includes a term that the lawyer will not promote suits upon frivolous pretenses. I find that an award of special costs is appropriate. The defendant shall receive special costs in this proceeding payable by the plaintiff. Okay. So you might think that this is all over and done. Well, there is more to the story. More happens. And so not only does Ms. Arbabi lose and have to pay special costs, but she was suspended. And then she resigns as a lawyer and is no longer a lawyer. She resigns from the Law Society. So this might end the investigation into her by the Law Society of British Columbia, but they have put out a statement saying, we're actually not bound to end our investigation. We can continue and we can find... So they can still apply other sanctions, which would probably be some sort of declaration forbidding her from resuming the practice of law. Even absent that declaration, I can tell you the chances that she's able to reapply to become a lawyer are very poor. I would expect the Law Society to reject that out of hand unless she can, for instance, show, say, if she can come in and say, hey, so as it turns out, I was developing some mental health issues. I'm now getting some treatment for it. I repudiate my past behavior. Then the Law Society might be going, okay, fair enough, take some additional remedial classes and we'll give you another shot. But short of that, I think she is done permanently. And a law degree is not cheap. It's, tens of thousands of dollars. So burning that to sue your neighbor is an incredible own goal. This is sort of Shakespearean tragedy in its nature. So I know there's going to be people in the comments going, oh, you're just, people sort of accuse me of like trying to suppress the truth or whatever here. Look how well it worked out for your girl here. It worked out very badly. If you want to do this stuff, you can get every bit of the success she did. I've covered other cases where people have lost hundreds of thousands of dollars to costs. Don't do this stuff. If anyone is telling you this is the way the law works, they are lying to you in very harmful ways. So it's tragic that Ms. Arbabi went down this path, but having chosen to do so, it's pretty necessary that she be booted out. So anyway, lots of people wanted me to talk about the conclusion to this one, and I feel it's important to talk about because I'd predicted she was gonna lose and gonna lose badly, and that her ability to practice law was entirely on the line here, and all of that has come true. So all of the people who in the comments said, hey, you know, she's gonna win, watch and see. Oops. Watching and seeing, and it's not the way that went. Anyway, thank you guys for watching. I hope you found this one to be interesting or educational. I want to thank my $50 supporters or Patreon supporters at the $50 level, CCFR, Canada's National Firearms Association, and the Canadian Shooting Sports Association. And at the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunk All of the Baileys, Cameron Johnson, Andrew Elsich, Vicky, and Dorky Dane. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.